You just pulled me out my car.
You were asked to get out of here.
You just pulled me out my car.
Welcome back to Advocacy, Alchemy with Professor Ross. Today we got a good one, guys. Today's lecture is a wild one. This lecture takes us down to Moncks Corner, South Carolina, where a late night DUI stop took a dramatic turn when another drunk driver slammed into a patrol car just inches from deputies and another DUI suspect. This isn't just one bad decision, it's two back to back, and both of them caught on body cam. You're going to witness a vehicle collision, mid-arrest, a suspect with a prior DUI and suspended license, an open container, and a narrowly avoided tragedy. We'll explore how multiple criminal charges stacked up fast. We'll walk through South Carolina's law, analyze this from a jury's perspective, and tap into our intuition as we break down how close this came to becoming a fatal night for law enforcement. With that, let's jump in.
Copy, Central Units, main channel 33 for Southside and Wildwood.
It's illegal.
You want somebody on the other side?
So they're pulling me out the car. Okay, I'm about to shoot you. Yeah, pull me out the car or whatever. I'm gonna sue y'all motherfuckers. Put me in handcuffs. Put me in handcuffs. Put me in handcuffs. Put me in handcuffs. For what?
Let me try. No, you don't have nothing. Take my phone.
195.
Take me to jail.
Copy, Central
I'll be
Units,
out
main channel
tomorrow.
33 is listed. Resume normal traffic. Central clear, 229.
No, it doesn't matter. It's no resisting. I didn't resist. You pulled me out my car just now. You just pulled me out my car.
You were asked to get out of here.
You just pulled me out my car. What do you want me to do?
Units responding for Treeland and Farmington.
What do you want me to do?
Yukon should be pulled over at discovery and prior risk.
What do you want me to do?
Whoa! God damn!
What the fuck?
Sit down, sit down.
Oh my God! Oh my God!
Door's locked.
Copy.
Hey. Hey, watch out. Oh, you got it open? All right.
Yeah, but you're gonna need EMS.
She's moving. She's moving.
More units of lost traffic.
She's moving. You get that open, sir? Is he responding? Yeah. Ma'am!
Ma'am!
143, you got one responding. All in attention at you. 995 has
She's not wearing a seatbelt. Help me get her out.
Okay. Come here.
Is she? Yes, she is. Can you
Here, back
got
up,
it?
back up.
All right.
Oh, she got it?
Yep, we got it.
All right. God damn.
All right, come on. Ready?
Hey, on. What's your rush of traffic over your block?
You got her? Put her on the side.
Let's get her out of the road.
Here, get on the side. Get on the side.
Let's get her out of the road. Let's get her out of the road. Just lay down.
Get on the side if we can.
Come around us.
Or actually, her neck. Leave her on her back so her neck doesn't get hurt.
Just lay down. You good?
Yeah, yeah. Everybody, I think we're all good. I don't know about him.
204. Y'all need these South units down there?
Just lay still.
Hey, hey, what's your name?
Lauren Skinner.
One more time?
Lauren Skinner
Okay, do you know what year it is?
is
You down there?
2025.
2025? Okay. Do you know who the president is? Trump? Yeah. Do you know if you're hurting anywhere? You don't feel any pain anywhere? Okay. Do you know what happened?
Central 14328.
No.
Sector 506.
You got in a car wreck. Okay?
You good?
Yeah, she's talking and everything. She knows what year it is and who the president is. She don't know what happened though.
Person or vehicle versus vehicle?
Vehicle versus vehicle.
No problem.
2207 got hit.
Don't smile at me, especially whenever you're out here drinking and driving. You about took us out and killed every one of us.
That was close. Let's break down the legal charges Lauren Michelle Skinner faces in this case. First, we have DUI, second offense. This is found under the South Carolina Code, section 56-5-2930. And what's necessary for conviction. The state must show the defendant drove a vehicle while appreciably or materially impaired with a prior DUI on record. The penalty range is 5 days in jail to 1 year in jail, fine of up to $5,100, mandatory ignition interlock, a license suspension. Here, the collision, her behavior, the open container they found, her prior history all contribute to a strong case for a conviction. Moving on to the second charge, we have driving under a suspended license, second offense. This is found at the South Carolina Code, section 56-1-460. And this occurs when a person drives with a suspended license and has been caught doing so before. Penalty is a minimum fine of $500. Jail ranging from 45 days to 6 months in jail. And the same driving privileges you're not supposed to be using, you get a further penalty on that. So if you're already suffering from a 1 year, hey, probably add another 2 years on top of it. Since Lauren's license was already suspended, her decision to drive while intoxicated compounds the seriousness of the offense. All right, let's move on to our third charge, transporting alcohol in a motor vehicle with a broken seal. All right, this is found under the South Carolina Code, section 61-4-110. It's illegal to carry an open, unsealed alcoholic beverage within reach in a car in South Carolina. The penalty is up to $100. Also, a person could face up to 30 days in jail. Now, this charge is typically a misdemeanor, all right? But when you bundle it with the second offenses for the DUI and the potential endangerment, all right, this helps establish a pattern of disregard for the law. And just a hint, if this kind of case were to go to trial, the state would probably seek each one of these charges. They wouldn't be so quick to throw away charges in a case like this. With that near miss, and that's what we call it legally, it's a near miss. But we'll find a better video to show near miss, and we'll just talk just about that. All right, let's move on to evidentiary standards. Let's apply the 6 levels of evidentiary standards, the core of understanding any criminal case. We talk about these every day because they are very important, okay? Let's start with number 1, mere suspicion. This is the lowest level. This is only a gut feeling or vague sense that something isn't right. It can't justify a stop or an arrest by itself, but it can spark some curiosity and cause the police to pay closer attention. All right, think of this. When you see someone stumbling toward a car at a bar. Now, you don't know for sure, but something does feel off. That's mere suspicion. It's not enough for some police action, but it starts the radar pinging. Now, here in this case, if someone had seen Lauren Skinner weaving a bit on the road before the crash, that might have raised suspicion, but it's not actionable just yet. Moving up to our next level, reasonable suspicion. This is when an officer has specific facts and logical inferences that can suggest a person may be involved in criminal activity. Now, this is enough to justify a stop and a brief detention. This is the we need to check this out level. There's behavior that's specific enough that something is likely going on. It's not just a vibe, but they got some actual clues. Here, the moment Lauren Skinner's car smashed in to the front of that police car with lights on is beyond suspicious. Officers didn't just have a reason to investigate, they had an obligation. Move Moving up a level, we have probable cause. This means the government has a fair probability based on facts that a person has committed or is committing a crime. This level justifies an arrest or going to go get a search warrant signed by a judge. Probable cause is when officers have enough real evidence, real stuff they can point to, and they can attribute it to a suspect. This is where all the gears are moving. This is where we're making moves now. We want to call it something new. We're making moves now. When you get to probable cause, somebody's getting arrested, or there's an operation being gathered up and about to happen. Moving up one more level, we have preponderance of the evidence. Now, this standard is used mostly in civil cases. It means more likely than not. If you're in a civil case, it requires you to have 51% of the evidence in your favor to win the case. If you're thinking about a scale, we just need one side to tip. Here in this case, if the officers wanted to sue Skinner for damages like medical bills, emotional trauma, or car repair, they'd only have to show that it's more likely than not that she caused this damage while she was impaired. And based on the video alone, they probably win that case. Moving up one more level, we have clear and convincing evidence. Now, this standard is used when the stakes are higher than money, but lower than prison. Like when we have child custody at issue, civil commitments, sentencing enhancements, employment, things like that. The evidence has to be highly and substantially more likely to be true. That means if you are in this kind of case, you need to have about 75% of the evidence in your favor to win. When you get to this level, there's really no more messing around. Everything needs to go towards something. This takes a lot of facts, a lot of evidence in your favor to prove your point at this level. The jury or the judge, they have to be pretty sure. And you're not just leaning one way. You're fully all in almost. I say almost because we got one more level. But in this case, if prosecutors want to argue that Lauren deserves a harsher sentence because of the recklessness or lack of remorse, they might present the crash footage and prior DUI to show that her behavior, it wasn't just a one-off. It was dangerous, repeated, and it could have killed a bunch of people at the scene there. Moving up one more level, we have beyond a reasonable doubt. Now, this is the highest standard of proof, and remember, it's required in every criminal case. It means there's no logical reason to doubt that the person that's on trial committed the crime. It's not absolute certainty, but we're talking real close. We're talking 90 to 95% here. All right, if we want to call this something, this will be when your freedom's on the line here. All right, so we want this to be way up there, real close to 100%, not 100%. All right, you don't convict someone unless the evidence leaves you sure of that person's guilt. All right, the state has to prove beyond a reasonable doubt that Lauren was driving, she was impaired while driving, had a suspended license, had an open container of alcohol in the car, and this wasn't just some accident. The body cam footage, the officer's testimony, her own confused responses, the condition of the vehicles afterwards, all that can be used to meet that bar. And based on what we saw, the evidence is strong, even before you get to everything else like her blood alcohol concentration, all that other stuff. All right, so let's move into the jury perspective. Now, let's shift into the jury box. You're no longer just a viewer, you're a decision maker. You just watched the body cam footage, you've heard the impact, you saw how close those officers and the other suspect was to getting hit. You watch Lauren Michelle Skinner be pulled from the vehicle, confused, disoriented, and according to police, impaired. Let's walk through what you'd have to decide if this case went to a jury trial. Now remember, this just happened a few weeks ago, so this is a long ways from going to trial, unless she's on some sort of probation, they have a immediate sanction. All right, so let's jump to these questions. First, do you believe the defendant was impaired at the time of the crash? Now, she doesn't deny drinking. We don't see the open container because our video stops too soon. But there's an open container, her speech is slow. She answers questions like, what year it is and who's the president correctly. Would that give you doubt? Or is it still clear to you she was under the influence? Now, we saw a car go by slowly right before, and then we see her car come into view, coming very quickly. Now, I do have that question once again that popped up on the screen. Do you feel like the police should have moved that car into the proper lane and maybe directed traffic to go around them? I don't know. Number 2, was this an honest mistake or was it reckless endangerment? Multiple officers and another suspect were just feet from the impact. Does her failure to recognize the danger mean she was too impaired to drive safely? Next, how much weight would you give that prior DUI? The law permits prosecutors to bring up prior convictions because this is a second offense. Do you see this as someone who didn't learn from her lesson the first time? Next, how you feel about her confusion? Was it genuine or was it convenient? She remembers the year and the president, but she doesn't remember what just happened. Does that make her more credible or does that make her less credible? And when you talk about credibility, that just means how much weight, how much do you believe what a person is saying? Would you hold her accountable or would you give her another chance? Does your verdict protect public safety? Does your verdict feel just? All right, so you tell me, guilty or not guilty? Okay, so let's call this what this is. This is a real near miss. This wasn't just bad luck, not a fender bender. This was a second time DUI offender, driving on a suspended license, open bottle in the car, who drove into an active crime scene and almost added manslaughter to the list. And what makes this even more sobering, this is how fast it happens. 2:30 a.m., one decision, one bottle, one moment. It doesn't matter. No, it's better. It don't matter if you know the president or the year. If you're too drunk to be behind the wheel, you're playing Russian roulette with others' lives. To everybody watching this, if you drink, don't drive. If your license is suspended, stay parked. If you ever get that little feeling in your gut that something isn't right, trust it. The law doesn't wait for a third strike. And over in Moncks Corner, South Carolina, justice pulled up with flashing lights and body cameras rolling. Remember, this is Advocacy Alchemy, and I am Professor Ross. Share the video, like, subscribe. Have a good Saturday. I'll see you tomorrow. Be safe out there.
Please subscribe to Advocacy Alchemy for more lectures from Professor Ross.